Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison
Yes, ma'am.
and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true?
Yes, ma'am.
The court is calling 2024 CR 3511, State of Texas versus Daryl Payne. Mr. Payne, if you'll come down. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Ron Ross for defendant.
And are you Mr. Payne?
Good morning, ma'am.
Good morning. All right, Mr. Payne, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, ma'am. Yes,
Did you
ma'am.
understand it?
Yes, ma'am. I understood.
Are you the same Daryl Avery Payne who was placed on deferred adjudication in 2024 CR 3511 for the offense of harassment of a public servant on July 29, 2024
Yes,
for a
ma'am.
period of 5 years?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 4 in Bear County, Texas. The defendant Daryl Avery Payne did then and there failed to report to the supervision officer for the month of September 2024, a violation of condition number 4.
How do you plead to that? True or not true?
True. True.
Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison
Yes, ma'am.
and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there proposed agreement?
There is, Your Honor, and is to deny the motion, alter and amend its conditions to include state ISF Cognitive Track. And the state is rejecting that other case and will be rejecting that today, Your Honor.
He's got a brand new
Assault case.
pre-file case. It's assault on a peace officer. It's case number 2024 PF 16955.
All right. And is that the case that's being rejected?
Yes, ma'am.
Yes, it will be, Judge. Just that Mr. Edelman is stepped out and he will be filling that out.
All right.
Judge, that is agreement. Mr. Payne has severe mental health issues.
Yes.
He's been to the hospital, state hospital, Laurel Ridge.
No, I understand
We're
that.
trying to
So,
make sure he's got some mental health treatment.
so here's my question. I don't understand how placing him in ISF for cognitive is going to help with the mental health issues.
Well, isn't that what that's for, mental health? And
Not necessarily. I'm aware of his mental health issues. His brother came into court before, stated that he would be living with his brother. So the issue we have with your client is there's major mental health issues, but also he doesn't have a residence. Probation, you want to weigh in?
Judge,
Just one moment, just give me a second.
Judge, there are major mental health issues. From my understanding, he is still welcome to live with his brother.
Mhm.
He does not meet the criteria for other programs that we have. And state ISF cognitive, we felt would be the best option to ensure that he's getting the medication that he needs and to address maybe some cognitive issues. I don't know necessarily that he will be qualified for it just yet, but that's our best case. Only because I would really like him to go through the evaluation portion of it. I've worked with his brother when he's come in to get him back on track with the Center for Health Services. Me personally, and it does seem that when Mr. Payne doesn't want to go, he just doesn't go, and then he disappears for a couple of days. So we really do want to make sure that he gets the help that he needs. He hasn't been on probation very long for our MIG caseload to further, work with him.
All
Judge,
right.
it's my understanding that he was living with his brother part of the time. Part of the things he got off his meds. And I guess he left the house because of that. If he gets back on meds and gets back straight, it's my understanding he can go back and live with his brother. And that's from what I understand, that from what I've been able to ascertain. I don't know. I'm not telling you the brother hasn't told me that because I don't know that reading what the probation has and talking to my client, I think that's the case.
All right, Mr. Payne,
Yeah.
it appears there was something that you wanted to say.
But I was, when I was in court the last time, I wasn't able to hardly walk. And when I went home, my brother told me he wanted me to do chores. And I wasn't, I was weak. And that's one reason why I left. It was my fault because I should be able to do chores right. I wasn't able to walk, I'm still weak. I'm gaining my strength day by day.
All right. So, does everyone think his brother is the best placement for him, or we just say that's the only placement for him? Is he receiving are you receiving SSI?
Yeah.
All right, so
I don't know, Judge, and I don't even know if he's gonna qualify. Well, I think what we're gonna do is, I talked about just resetting this and having him evaluated. Probation said, well, that would kick him at the end. Let's just start the process and come back in maybe 30 days to see if he doesn't qualify, then we'll have to go to something else. But whether that's the best place, I don't really know for sure.
all right, this is what the court is going to do. Court will follow your agreement. The court is going to deny the motion. Court will note that 2024 PF 1699 is being rejected. Court is going to alter and amend conditions to include state ISF cognitive. There's going to be partial GPS waive fees. That can be through the jail, and that'll be until further notice. Re-refer to Center for Healthcare Services. If he does not qualify for ISF, then we'll bring this back. And counsel, if you could check with managed assigned counsel, or either if you go to the community court, they may have a different placement for him for housing that will address the mental health issues as well as everything else. Because if he's receiving SSI, and if he can't walk, which each time he comes to court, it appears that he's struggling health-wise, then maybe he can't do chores. I don't know. But I don't know if being at his brother's home is the best placement for him or not.
Okay.
I was taking my meds. I was taking my meds.
Hmm.
I made the mistake of leaving. My brother didn't tell me to leave.
Okay.
I left on my own because I was weak at the time, and I'm gaining my strength. My brother did everything for me. He fed me. He washed my clothes. He washed the dishes. He took me to the Center for Healthcare Service
Okay.
on East Houston and South Palmetto.
Mhm. All right, just 1 second. Yes.
Judge, I would also ask that we put on there after release from state ISF, the MIC and Genesis program.
All right. So we include the MIC and Genesis program. And here's the thing, sir. If there's some issue with your brother and you feel you need to leave,
I ain't leaving no more.
no. I mean, here's the thing. That's happened last time. That's why we're here now, is because you stop taking your medications, you leave. You can't do that. When you stop taking your medications, you know what ends up happening?
Yeah.
You pick up a new case
Yes,
and you
ma'am.
end up back in custody.
Yes, ma'am.
And let me explain something to you. You may end up in custody and end up before a different judge with a different prosecutor, a different attorney, and you could find yourself in prison.
Yes, ma'am. I understand.
All right.
Miss Stephanie.
All right,
Can I have another chance?
yes,
Thank you.
you're welcome. All right, thank you.
Just make sure you take the notes.
Yes, sir. I promise, man. I'm gonna obey everything. I
When you
promise.
get out of this program, they're gonna put you in another MIG program. They're gonna follow, they're gonna keep helping you with mental health. You just need to keep doing what you gotta
In
do.
2004, I made 7 years probation.
Okay.
I can do it. I
Okay.
can do it, Stephanie.
All right, here's the thing. If there's an issue with your brother You can come to court and we'll address that, but you
Yes.
can't just
Yes, ma'am.
leave.
Yes, ma'am.
All right. Good luck to you.
Thank
luck,
you
good
very
luck.
much.
Good luck, sir.
You're welcome.
Honorable Judge Deputy.
Oh, thank you so much.
Thank you, Your Honor.
Court is calling 2023 CR 7272 State versus Lisa Godwin Pryor. Can I have parties announced for the record for the state? Defense?
Renee Munoz.
And are you Miss Pryor?
Yes.
All right, can I have a file stamp for a motion to revoke, please? No problem. All right, Ms. Pryor, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Lisa Godwin Pryor who's placed on deferred adjudication in 2023 CR 7272 for the offense of tampering with the government record on October 16, 2023 for a period of 3 years? Is that you?
Right.
All right, state.
In Bear County, Texas, the defendant Lisa Godwin Pryor did then and there fail to report to the supervision officer as directed for the months of June and July 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State?
Deny the MTR.
No. Do you waive the other allegations?
Apologies, Your Honor. Yes, state waives the remaining violation allegation.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, I
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, referral to felony drug court, 90 sober support meetings in 90 days. And if Ms. Godwin is not accepted into felony drug court, bring her back to court, figure out what to do.
All right, so here's my question. Why is she not reporting?
If I may answer with on behalf of my client, Judge.
Yes.
She was in the midst of heavy drug addiction. Your Honor, she was at the time of her plea, our understanding, released, and she wasn't ordered to the mental health caseload, which is something we'd additionally be requesting. I think a referral for felony drug court was ordered. However,
Yes.
that never matriculated. It was never received. So there was that lapse. So she wasn't considered for it. Unfortunately, that might have slipped through the cracks on that particular occasion. In speaking with probation, it seemed to be the case that had occurred. And it seems that she was let out into the community without the tools necessary to be successful on her probation. If you notice in the motion to revoke, she was actually showing up to go test, and there's numerous positives for methamphetamine.
Okay, so I ordered the MIC evaluation and I ordered a referral to felony drug court.
Yes, Your Honor.
So you're saying there was some breakdown in communication somewhere?
That's our understanding, Judge. In speaking with Ms. Abrams, she stated that the request was made for felony drug court. However, it was not received on the felony drug court end to start the process to review. And I think she was let out. She wasn't given the access to those resources then. And she's fell into the usage, Judge. She was showing up. However, we believe that something more intensive was likely more needed for her in terms of her methamphetamine usage.
Was the MIC evaluation done?
Did you ever,
Yes, ma'am.
the MIC evaluation was done? Okay. You attended that?
Oh, just one second. Ms. Abrams, what was the result of the MIC evaluation?
Michael?
Okay. So she's on mental supervision caseload.
That's my my apologies on that, Your Honor. She
Oh, no
said she
problem.
hadn't been on that. It seems like she did the evaluation. But in relation to the substance use, Judge, that's where I think a lot of these issues stem from. She has violations for testing positive, and there's nothing in my purview that's criminal based, but more so her needing help and treatments. The underlying offense is, I believe, a tampering. It's not nothing violent in nature. I don't seem to her to be aggressive or violent or a threat or danger to the community, but rather the red flags indicative of her needing substance use help. Further, Judge, we also, when she was in custody,
I'll be there shortly.
asked PICU, the Population Impact Control Unit for Bear County, to screen her, and they deemed her eligible for what's called paid forward at Haven for Hope, which is a sober living.
Yes.
And also, as the court's aware, transition into a permanent housing as she would have housing issues. It's our understanding that probation would more so see if she could qualify for felony drug court, and perhaps if she doesn't, hopefully maybe do that paid forward program at Haven for Hope, which she is willing to abide by, Judge. But all these things are indicative of the fact that I think that she needs help and treatments over just straight incarceration.
All right. There was something you wanted to say to the court? I saw you raising your hand.
Oh, I didn't know that it had
Well,
already
just
been.
1 second. I'll need to put you under oath. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Lisa Pryor.
All right, what did you wish to say?
Oh, I just, was confused on the being in the probation part, mental health probation.
Okay,
Because from what I knew, I wasn't in that caseload yet.
all right. Probation, what is your recommendation?
Judge, being that we did not have a felony drug court evaluation, I would like to see what the outcome of that evaluation is, the 90 sober support meetings in 90 days, and if not accepted into felony drug court, move forward with the paid forward at Haven for Hope.
All right, is there a need for an updated TAP evaluation or no?
That's a good question. I wonder when the last time one was done for her.
There was a TAP revision done April. It would not hurt to go ahead and get an updated TAP. Judge.
All right, court will follow your agreement. The court is going to deny the motion, alter and amend conditions to include the following in custody. There's to be a referral to felony drug court. And there's to be a TAP evaluation in custody. If she's not accepted in felony drug court, then we'll have this case brought back here because I want to see what the TAP evaluation says.
Sure.
Then there's going to be 90 sober meetings in 90 days. And probation, you said she was approved for MIC. She doesn't think she's on the MIC caseload, if you can confirm that.
Yes, Judge.
And so I will say MIC, although she should still already be on MIC supervision, but I'm going to request MIC supervision.
Sure.
Is there anything else you need from the court to be successful? Let me see, when is her expiration date?
Oh, 26, Judge.
Okay. Is there anything else from either side? All right, we can go off the record. Here's the thing. You can't get in your throes of addiction, stop reporting, don't show up, because then what ends up happening, you're looking at revocation. And you're looking, in this case, at potentially 10 years in the prison. Do you understand? If there's an issue, you need to let probation know. If you feel as though you're about to start using, let probation know. And when you do those sober meetings, you need to get a sponsor. Do you understand? All right, good luck to you.
Thank
Thank
you,
you.
Honor.
All right, everyone, I'm going to take 5 minutes. I'll be
This case begins with what seems like a routine plea hearing. The defendant stands before Judge Stephanie Boyd seeking deferred adjudication for an evading arrest charge. She calmly answers the judge's competency questions, confirms her understanding of the 10-year prison exposure, and assures the court that no one coerced her into a plea. Everything appears standard until the sentencing discussion begins. The defense paints a sympathetic picture: a dedicated mother raising a 7-year-old nonverbal autistic child, caring for a 3-year-old, and running a small baking business. They ask for leniency on fines and community service, hoping her responsibilities will influence the court. But Judge Boyd's tone sharpens instantly the moment she asks, "Why were you driving 80 miles per hour?" and the defendant responds, "I wasn't driving." That single statement detonates the calm. Judge Boyd reminds her that the charge is evading in a vehicle, and that a jury trial can be arranged if she wants to dispute the evidence. The state then discloses the key detail: a dash cam video unmistakably showing her stepping out of the driver's seat. Judge Boyd confronts her directly. "Why are you pretending you were not driving?" The defendant blames nerves, but Judge Boyd shuts it down. Nervousness is not dishonesty. She presses further, uncovering the real reason. An argument with her boyfriend, Eduardo Ramirez, sparked the reckless 80-mile-per-hour drive. Judge Boyd delivers a powerful message. With 2 young children at home, she could have easily ended up another person on the news that's dead. The court imposes strict conditions: 4 years deferred adjudication, a $1,500 fine, 180 hours of community service, parenting classes, random UAs, proof of employment, defensive driving, and a no-contact order with Eduardo Ramirez except for court. Firm, direct, and unwavering, Judge Boyd makes one thing clear: this mother must put her children first.